Hello, everyone. Welcome back to the Divorce Unplugged podcast. I'm one of your co-hosts, Nicole Cox, and you might know me on socials as the Family Law Liaison.
And I'm Keegan Burke. I am generally recognized as Divorceology and on all the socials. But my disclosure is not a lawyer, not lawyering. This isn't legal advice. Not trying to give legal advice, looking to have an open dialogue with Nicole around all things divorce and custody. So,
And we love that, Keegan, because it's fun to have these open dialogues. I am an attorney, but I am certainly not yours, and I am not giving you guys any legal advice today. This is just fun conversation.
exactly. And today we are going to talk about modifications and or life changes or things that give you the opportunity to modify your generally custody, but child support or spousal support orders. We'll walk through kind of the high level, things that you want to consider, right? Life changes, jobs, income, school, health, relationships are all things that can play a role in it. But really, the question is when and how do you go about doing that? And if you have a coach, if you should go about doing it. So,
That's a good one. Definitely. Always ask your coach, is it worth it to go back and modify? I mean,
yeah,
it's a
great
pain.
question.
There's a lot involved.
Yeah, there's a lot of things to consider, right? But first off, I guess I'd ask you, what are some of the things that we know can be modified?
Okay, so certain things can be modified. I think we just discussed child support, parenting plans, parenting time, spousal. Sometimes holidays actually can be modified as well. And in certain circumstances, you can use a modification hearing, which my client is doing right now, to get some court appointed officials like forensic counselors involved. Yeah.
Yeah, yeah. Now, I would say all of those things are modifiable for assuming you have reason, right? Good cause, if you will. But I would always say that before you run into court and turn it into a court battle and leave the decision up to a judge or a professional on your
Mhm.
case, do everything humanly possible to try to negotiate the changes that you seek, maybe the changes that your kids seek or that you need, something happens that you need some reprieve or relief from the other party. Ideally, you're working in a cooperative environment. Now, I know, and Nicole knows,
Yes.
that isn't always the case, and you need court. But ultimately, if you were to ask me, hey, what should I do? I think the first stop is go to the other party and figure out, what are the things that you need to do. However, don't just run to the other party blindly and lay out your case or lay out your argument or make an argument. Have a coach give you guidance on what to ask for and how to ask for it in hopes of getting what you need, in a sensible fashion.
Right. And you actually made a good point just a minute ago, which I thought about. As children grow older, there's modifications necessary because they have different needs, and usually their needs grow.
100%. And I think in most cases, right, it's the most reasonable change in my mind, right? As the kids' needs evolve, as their desires evolve, maybe as their experiences evolve, those are justifiable reasons to go make modifications. And by the way, kids as they get older have more of a say, right? Not to put the pressure on the kids, but they do generally get more of a say. And until that point, right, it's you're making sure that you're following the orders too. Just as a quick anecdote, don't just because a kid's saying one thing, you think that the kid gets the say, right? You're the parent. Follow the order until the orders change or an agreement is met.
Exactly, exactly. And there's a few more things that we can kind of get into about the modifications and when you can do it and what justifies it. Let's talk about the standard of a modification, which is definitely there has to be a material change in a circumstance.
Yes. Yes, and material changes are, depending on jurisdiction, of course, the way they define that is always a little bit different from state to state. But I think you can generally land on things like job loss or gain, relocation, change in health or ability of a particular parent. Now, remember, that whole ADA piece from a parental's constitutional right perspective around ability. Don't get caught up, trying to fight a battle there. Change in child's needs. We talked about it already. Changes in your familial dynamics. Maybe you get married, or you have another baby with your new spouse. That's a change in your life and your children's life. And then, of course, even if you don't lose a job, but your income goes up or down significantly, that it is either unmanageable to pay the support you're paying, or maybe you should be paying more support,
Oh,
depending.
let's not make that face. There are
Yeah,
many situations where there should be more support given, and it goes
yeah,
both ways. Honestly, I just had a client in a modification, and it is my female client, one of them, and she was paying too much, and I'm saying, "How are you putting out all this money?" And he stayed underemployed the whole time. So,
mhm,
and yeah, and modifications are interesting. I mean, you can modify a temporary order in some cases, which is a bit of an uphill climb once you got a temporary orders in place, but there are also some things that just can't be modified,
yeah. Property division, right?
right?
Past due child support or arrears. Now, I say that exclusive of the finding of fraud or something that maybe wasn't disclosed properly that would open the door to some type of revision there. Because that happens, more frequently than people believe or understand. But it
And
really,
absolutely, and that's a
yeah,
good point because in my modification today with one of my clients, it was, okay, underreported income, inflated income
mhm,
versus what can mom afford now?
yeah.
Those were some huge, issues that were covered.
Yeah, yeah, for sure. And so I think it's important, right? Just generally speaking, from a coach's perspective, it's you don't want to get caught trying to unwind what's already in place. You want to be focused on what are the things that are tangible that need change now and going forward, right? Like
Yeah,
because unwinding, appealing, trying to argue historical doesn't land well with courts because they consider it, case closed. We're not going to retry the same topics. What's new, what's changed, and what's relevant to best interests, what's a
right.
material and impactful, change in the circumstances before us, and why should we be making this change?
Right, or maybe father finally got a job, and then the vocational assessment reflected that, and it was imputed on him. Things like that. Just give an
Or
example.
maybe mom got a job or actually reports the income that she could have been earning or has been earning through another entity for a period of time.
And it goes
Uh,
both ways. It does.
the cookie crumbles for everybody,
It does.
no question. So I guess with that in mind, right, what are some of the things that you need to think about in terms of preparation?
And it always, you first have to look at, what are we modifying? Are we going into a modification with 4 different issues? Then we have to look at every single issue, strategically and separately. So if you're modifying child support, if you're modifying spousal, things like that, then obviously you have to have all of your financial documentation in place, and you have to show everything. Can't hide it.
Yeah. No, I agree. And, the other thing too, from a coaching perspective, it's modifications around support, custody, all the things, right? It's a really easy thing to think just because you have a good reason to modify your situation. It's easy to get caught spending unnecessarily on things that maybe you could have negotiated out of, or maybe didn't need to be modified. Right? If the net outcome is about the same, was it something that you really need to go spend 10, 20, $30,000 on, or did you open up the door to a net negative outcome, right? Like, are you
Mhm.
better off just staying the
Yes.
course and letting things ride? Because remember, we say it all the time, nobody wins in court, right? No,
No.
almost ever. So
Well,
measure
you made
your needs.
You made a really good point, and as a coach, this one specific isolated incident on modification with one of my clients, I mean, we sat on it for quite a while, and I was like, "Okay, you literally didn't do well in temporary orders. Nobody showed up for you. It was not a good thing, and now at some point, if we can't get in front of a judge for trial in the next 2 months, you are literally not going to be able to survive longer. You have to pay him all this money. You have 2 kiddos to pay for, to totally financially take care of, and, things change with jobs, etcetera. So at that point, but I think we waited long enough, like months and months before we were like, "Okay, we have to modify because you can't you can't pay him spousal support anymore on top of all the child support and the schooling and everything else." So that was something that I was like, "Okay, I think it's time, definitely." And you made another great point, which is this is going to be an 8 to $10,000 venture, regardless. You're walking in
All day.
and a modification, yes. So there was that. But there's also, like we were talking about, children that have special needs. And those special needs just pop up. And if you try so hard to get some sort of resolution, like that's a settlement with the other party and they just refuse, there's a point when there has to be a motion filed in front of a judge.
Yeah. Yeah, and I would say just one kind of separate thing that just came to mind for those that are in a situation where maybe you've had a downward trajectory in income, a job change, maybe you've lost a job. I think all too often folks think that, well, I don't have the money or I don't have a job and I don't need to pay or I can't pay and I'm going to go into court and just say sorry. That's not going to be adequate. You need to file for relief so that you can establish jurisdiction back to that date, right?
Right.
Maybe you can't pay, but at least you're starting the clock so that you're not on the hook for that payment, whether you have the income or not, because the order is there and you're expected, whether you're accumulating an arrears balance on it or paying it, that balance is going to be yours until you've sought the proper relief from court, particularly around child support, particularly in California is what I'm speaking about now. But I think
Right.
generally speaking, unless you get the support modification on the calendar, you're required to pay it come hell or high water. So
Right.
just
And
get
then and
don't be
then like you
lackadaisical
just
about it.
said, yeah, but like you just said, then there's jail time involved in different states other than California. You can end up in accountability court and not
Yep.
even get to put in and file for your modification and spend jail time.
Yep.
So it's a
Yeah.
serious thing. Pay your child support.
Yeah. For sure. And then, I think anytime you're getting into court, right, it goes back to all the fundamental approaches that we talk about all the time, right? Documenting, being very organized, having your timelines, minding your P's and Q's through certain communications, making sure you are communicating, right? In a lot of places through the eyes of the court, it's they're going to measure you by the level of cooperation. If you're the one always being the problem, always stonewalling responses, always being contrarian to every topic and issue. Again, just because you've got an order and you've been operating in a status quo environment does not mean that you're no longer under the microscope. Once you hit divorce and you get custody orders, the court's involved in your life until the kids age out. So
Right.
you need to manage your life and the way you process things through a very consistent methodology and vision, right? Everything I do is going to be reviewed. Everything I do is going to be perceived in a certain way. And I think it is also beneficial to the equation if you are operating responsibly, you are operating with, in good faith, if you will. Because at the end of the day, if you end up back in court on a modification, whether it's yours or the other parties, all of your actions and behaviors are going to come to light.
Well, and like you said, and we talked about it before, and this is a big one for me with my clients. Always let's step back and think about this modification. And is it really going to change your life that much? Is it really that worth it?
I'll give you a quick example, just because I think it's important, right? Child support's a good one, and I think the one that gets modified the most frequently because that's where people's lives change the most. Um, let's say you are paying, I don't know, $1,000. Let's just use an easy number, and you've got a job change and you've lost some income, and really the child support payment should be $900, right? So it's
But
an
is
incremental
that
change.
worth the change?
Right. $10,000 to have an attorney or to go in and fight it is, where's the break even? You're gonna even if it's $5,000 to fight it, it's
Right.
gonna take a lot of months at $100 improvement to make that money back.
Mhm.
So, again, where I think the system is broken, but it's one of those things that a coach is absolutely going to guide you through that. An attorney's not because they're gonna make the 5 or 10 grand to go argue it, and they'll say you have a reason to. They're not gonna say, "Oh, well, six one half dozen the other."
And they may or may not prep you for your modification hearing, or it might happen within an hour or two before. Now, I'm not saying that that's every attorney because I personally have met some that are very on point and will prepare you very well, but it's still a hearing and you have to be prepared even though it's a modification.
Yeah, absolutely. The other thing too around modifications, I think I wish that it was more of a measurement, and it's weird because in one vein, I think that I wish it was measured, but in another vein, I think that it is measured, and that is frequent flyers, right? Vexatious litigants, folks that file a motion for every single thing,
Oh
enforcement,
my god. Yes.
contempt, random modifications that just are using up the court's time. They're frustrating the process of settlement and negotiation. It's like their battlefield. They wanna drag you into the mud no matter what.
Oh, I feel you on that. I think the worst are the modifications of temporary orders hearings, and you get like 3 or 4 motions filed on you in one day to modify temporary orders, and you're like, "What? Why?" And like we've talked
Mhm.
about before, and I do with my clients a lot. Yes, right now this person is in contempt of court, but is it worth going in and proving it for a $10,000 small, like, contempt? No, and it's the same with modifications.
Yeah, not only that, for those that don't know, if you've got other matters pending and you file a contempt charge,
Oh, you said that.
you're going to really disrupt the other matters that are probably more important. So, because the other side has the right to be silent and not
Right.
incriminate themselves in their contempt hearings. There are waivers and things you can do around that, but nevertheless, it's just something to be mindful of. It
Mhm.
also can come across as spiteful. And you don't ever want to be that. You don't want to be getting back at your ex through the court system because, sometimes you can shoot yourself in the foot just trying to over leverage the system to get what you want or to be too forceful with it. So,
Well, of course, because it becomes retaliatory.
mhm.
So, but, like, in closing on modifications, I think we covered them fairly well. Be very careful if you decide to file a modification, if that's something that you want, because things don't always turn out the way that you want them to in a modification. And then it's giving the opposing party the opportunity to come back and maybe turn it around on you.
Yeah, 100%. And I would close on expectations of modifications. As with anything, right? You have to go in with tempered expectations. You might feel like you've got all the evidence in the world, you've got a really good case. Listen, all too often for either party, it doesn't go the way you hope it's going to go, and or it goes much longer than it should or that you hope it to. You might be looking for relief of something that, should be resolved in 2 or 3 months, but it takes 6 to 8. And then that issue is gone anyway and you've wasted all the time and all the energy and all the expectations. The other thing too is don't go in with the expectation that you're going to win anything, quite frankly, and measure your success through a very finite lens of what is acceptable, what battle will I likely lose. If it's going to be a war, then you're going to lose a couple battles in the process, but really kind of get your mind around the process that it's not easy, it's not fast, and the outcomes are never what you hope they're going to be. So, again, back to my original point, have a coach, look to mediate or negotiate where you can, and then at least you're both in some level of control of the outcome versus leaving it to somebody who's overworked and underpaid.
I agree. Absolutely. Try to settle first.
Yeah. Yeah. So,
Good.
until next time, like, listen, subscribe, do all the things. We appreciate you all, and we're looking forward to the upcoming episodes.
Yes. Good to see you guys. See you soon.
Thank you.
Bye.